Good morning and welcome to the August docket of the Kansas Court of Appeals. This morning we have one case on the docket. As I think both counsel know, my name is David Bruns and it's my pleasure to be able to preside over this panel today. Joining me today, and I don't know the position on the screen, but I'll introduce Judge Catherine Gardner, who has been on our court since 2015. Prior to that, she practiced both in private practice as an assistant attorney general and has served in both the federal and state courts. So welcome, Judge Gardner. And then one of our newest judges, although she's moving up quickly in seniority on our court, is Judge Amy Fellows Klein, who officially joined our court after being confirmed by the Kansas Senate in February, but was nominated or appointed, last year by the governor. So prior to joining us, Judge Klein practiced in Wichita. Today, the case that we will be hearing is a criminal case, which is State of Kansas versus Shimer or Shimer. I don't know. You can correct me on how to pronounce his name exactly. Will counsel state their appearances?
Your Honor, the State of Kansas appears by Tony Cruz.
Yes, Mr. Shimer appears by Rick Kittle of the Appellate Defender Office.
And Mr. Kittle, as you know, each side has 15 minutes to argue, but you can reserve some time for rebuttal if you would like to do so.
Yes, I'd like 3 minutes, please.
So 12 and 3. Well, as I think both of you know, we have read your briefs. We've also been provided with pre-hearing memos, so you can get straight to your oral argument. So, Mr. Kittle, you may begin.
Thank you, Your Honor. Again, I'm Rick Kittle. I represent Mr. Shimer. This case involves a car stop on I-70 in Geary County and the subsequent search of the car. Unless the court has specific questions about the facts, I realize I'm probably not going to have time here to discuss everything that's in Mr. Shimer's brief, but there are a couple of points I'd like to discuss, beginning with the issues surrounding the motion to suppress. Of course, the first point here is the legality of the car stop itself. That's a seizure under the Fourth Amendment, and an officer must have reasonable suspicion based upon articulable facts to legally make a car stop in that situation. The infraction that was involved here was KSA 8-1522, which involves the requirement of driving a vehicle in the right lane of traffic when there's more than one lane, as there is on that area of I-70. And just to refresh the court's memory here, Blake, the officer involved here, was stationary on the median in I-70. He was watching the westbound lanes of traffic. He saw what he believed to be a violation, so he took off and headed west on I-70. He got to the car that he was seeking, discovered that there was no violation. At that moment, he looked to his left across the median towards the south, the eastbound lanes of traffic, and saw at that moment what he thought was a violation of a car, Mr. Shimer's car, traveling needlessly in the left lane of traffic. So he crosses the median, catches up with Mr. Shimer's car and stops it. There are a couple things with the stop that I think need to be discussed. First, there is video of all of this. And Blake, the officer himself, testified that in order to safely return to the right lane of traffic after passing a vehicle, the passing vehicle needs to be 3 to 4 seconds ahead of the vehicle it's passing, which at interstate highway speeds translates to over 100 yards. I would submit that when you look at the video here, what can be seen there and what you can see on the video is exactly what apparently Blake saw and thought was a violation. What we have in that situation is not a violation, and no one could reasonably believe that that was a violation if, according to Blake, you have to be 3 to 4 seconds ahead of the car that's being passed. The other thing that I think is significant here is we need to look at the statute itself. 8:15:22 says that a vehicle should be driven in the right lane of traffic except when overtaking and passing another vehicle. Subsection A of the statute says that the car must be driven in a single lane and not moved from that lane until the driver first ascertains that such movement can be made with safety. So if the car is in the left lane, as it was, the only person who can determine whether it's safe to move the car back to the right lane of traffic, according to the statutory law, is the driver himself. The law enforcement officer doesn't have any part in making that decision.
So how could that law ever be enforced then?
I don't think it can under the language of the statute, because the decision is entirely when to move. I would argue in this case that, and what the testimony was from Mr. Shimer was that he was in the left lane of traffic. He moved back into the right lane of traffic when he could see the white semi truck in his rear view mirror, and that's when he believed it was safe to move back into the right lane. Now, we don't have any other evidence to refute that, other than Blake's testimony that he thought the car was needlessly in the left lane. But Blake, under the statute, is not the person who determines when it is proper to move the car back into the right lane of traffic.
But Mr. Kittle, wouldn't you agree that regardless of whether the officer was correct and regardless of whether or not your client could have been convicted of this violation, that we're looking at a reasonable suspicion standard based on an objective officer's belief?
Yes, I guess I'd say a couple things about that. There's a whole body of litigation involving this officer now in the Kansas Supreme Court. And so I think that's a good reason to question whether this is a reasonable objective standard that's being applied by Blake's in these situations. What we have on video seems to refute his own testimony about what is proper in this situation. And I don't think it makes any difference about that objectively reasonable standard when we have the clear language of the statute making the movement of the car completely dependent upon the perceptions of the driver rather than the law enforcement officer.
And just so it's clear for all of us, make sure I understand. It's my understanding that the district court viewed the video and considered that as part of her decision.
Yes, I believe that's right.
Okay.
The next point, if I can move on to another part in the time that I have, and
please do.
In this case, there was a motion to suppress, of course, which was denied by the district court. And then after these three cases came down from the Kansas Supreme Court, Jimenez, Schooler, and Lowry, Mr. Shimer filed a motion to reconsider the motion to suppress. Again, Blake is an officer that's involved in two of those cases. I'd like to talk briefly about Jimenez, which I think is significant here, because in Jimenez, Blake had stopped a car for a traffic infraction. Just like this case, Jimenez is the driver and there's a passenger in the car. Neither of the occupants of the stopped car could speak English very well. So Blake asked the driver to come back to his vehicle, where he used a translation app to ask Jimenez a number of questions about travel. Where have you been? Where did you stay? How long have you been on the road? And so forth. Now, before they went back to the car, to Blake's car, this was a rental car that was stopped, and the glove box was opened, and Blake saw a bundled roll of cash wrapped with a rubber band in the glove box. So he's suspicious, I guess, at that point. But he takes the driver back to the car, asks her a number of questions about her travels. 5.5 minutes pass before he actually transmits the license and registration information to dispatch. So the holding in Jimenez, after the case eventually makes its way to the Kansas Supreme Court, is that traffic stops cannot be measurably extended beyond the time necessary to process the infraction that prompted the stop, and unless there is reasonable suspicion of some other criminal activity. So the questions in this case is, first of all, was the traffic stop measurably extended? I submit that it was, because when Blake went up to Mr. Shimer's car and spoke to him, they spoke in a completely conversational tone. Blake, for the benefit of the video, at one point says, "Oh, they're very nervous," as he's walking back to the car. He asked Mr. Shimer to come back to his vehicle so he could talk to him. Mr. Shimer says, "Am I being detained? Can I just stay here in my car?" And Blake says, "Yes, that's okay." So Blake goes back to his vehicle, starts writing a warning citation, which is what he said he was going to do initially, stops that, and then uses his phone to call Epic. Now, at the suppression hearing, Blake was questioned about this. He was told what Epic stood for, which is El Paso Intelligence Center. He was asked what that agency is, and he says it was an intelligence agency, which should be apparent from the name of the agency. But he really didn't seem to know much about what it was or what he was hoping to achieve by contacting them. He also said that he called Epic in less than half of the traffic infractions the traffic stops he made. He said he did 4,000 a year, which seems to be an astronomical number, but maybe that's what he does. But if he's going to write a warning citation, why is he even calling Epic? And the problem, of course, here is that he didn't get any information from Epic, at least not initially. And then after being on the phone with them and waiting for information, after 6.5 minutes after he makes the traffic stop, he finally transmits the license and registration information to dispatch. Our argument is that just as in Jimenez, the period spent asking these needless questions about travel measurably extended the traffic stop beyond what was necessary to deal with the purpose of the stop. The Epic check in this case measurably extended the stop of Mr. Shimer beyond what was necessary to deal with the alleged violation of 815.22.
Mr. Kittle, what length of time are you alleging that the Epic stop extended, the Epic call extended the stop?
Well, if you look at what happened in Jimenez, what they say is the time from the car stop until the time that the information was radioed to dispatch was 5.5 minutes. I believe in this case, the time from the car stop until the radio to dispatch was even longer. It was 6.5 minutes. And I believe one of the cases, it was either Lowry or Schooler, there was also a 6-minute delay. So it doesn't have to be a great period of time. And what we have in this case exceeds what was found to be illegal in the Jimenez case. So I think there was an improper extension of the detention in this case beyond what was necessary. I don't think there was any other information that would have provided reasonable suspicion for the officer. What was relied upon below was nervousness. And of course, the DeMarco case talks about that. The off-cited DeMarco case says nervousness standing alone is not sufficient to show reasonable suspicion. Now, the state's not claiming that's all there was in this case, but the other things they're talking about are, one, Mr. Shimer apparently left his right blinker on during the course of the traffic stop rather than turning it off. Now, the state never explains why or what criminal activity that's an indication of. Leaving the blinker on could have been an oversight. It could have been part of nervousness. It could have been a deliberate act. I assume that Blake had his flashing lights on during the stop, and it might not be a bad idea to leave a flashing light on during a traffic stop on the interstate highway.
Mr. Kittle, you're at about 12.5 minutes. So if you want to hit on any other points, You might wrap up this portion, and then I'll give Mr. Cruz a little additional time if he needs it.
All right. Thank you, Your Honor. So I guess I would just say we don't have reasonable suspicion that would allow the extension of the stop. The other point I was going to try to make dealt with the speedy trial issue. The only thing I would say on that is look at the hearing that occurred on September 1st, 2016, because that was the hearing which the district court said Mr. Shimer completely waived his speedy trial rights. But I don't think that hearing, that decision is supported in what you can read in that transcript. And I would submit the balance on the case on the brief for the court's consideration. Thank you.
Thank you. Mr. Cruz?
Thank you, Judge. As far as the traffic stop, I believe that the court heard evidence from Officer Blake and from Mr. Shimer and found the Officer Blake's testimony to be more credible than Mr. Shimer. As the court pointed out, that a strict reading of that statute being KSA 8-1522, the only person that would be able to, I guess, determine when they could safely change lanes would be the driver, which is something that any officer would never know, period. So that would make the statute invalid. As far as the length of the traffic stop, Judge Segura noted in her written memorandum that when the officer returned back to his patrol vehicle, he had already had reasonable suspicion of more criminal activity. And the reality is that it wasn't the epic check that actually extended the traffic stop, that it was dispatch for whatever reason, took over 20 minutes to respond to Officer Blake. And if the court has watched that video, there were several times where it's quite evident that Officer Blake is really frustrated with dispatch because they're taking so long. And not only did he call over the radio, but he even called on his cell phone. At one point, I believe that even tells him, hey, forget everything else. Just tell me if he's got active warrants. So I think Officer Blake was trying to expedite that the request heading to dispatch, just for whatever reason on this particular stop, dispatch was taking extremely long time.
Counsel, isn't the issue the delay in calling dispatch, not the delay in dispatch getting back to the officer? Isn't that what they're complaining about? The fact that he waited to call dispatch, I think 5 or 6 minutes?
That is their argument, but my argument is that even if he had called dispatch and then called Epic, we'd still be in the same realm, if you will, because of the fact that it wouldn't have extended the traffic stop because dispatch still would have needed all that extra time. So I think in this particular case that we're getting into a situation where the defense is asking the courts basically to dictate the specific steps an officer needs to take during a traffic stop, that he's got to do this first, then this, then that. In this particular case, I don't think it would have mattered, because even if he had called dispatch first, then called Epic, there would have still been this 20-minute lag time, if you will. So they wouldn't be complaining about the Epic call. They would have been complaining about dispatch taking 20 minutes, which was outside the control of the officer. So I think in his particular case, that delay doesn't really matter who caused it, because there is still that delay. But as the court found, he had reasonable suspicion back when he got back into his patrol car. So,
and the reasonable suspicion, let's talk about that a little bit.
Sure.
One of the issues was the fact that Mr. Shimer remained in the vehicle. Why is that suspicious?
I don't think that it was the fact that he remained in the vehicle, but it was just the terminology he asked the officer about whether or not he was being detained or not. That's a very odd term for a motorist to ask an officer. So I think that heightened Officer Blake's question of that was a very odd term to use during a traffic stop. So it's not the
Was
fact
it an
that
odd request? Is it an odd request to ask a driver to get out of the vehicle in the traffic stop and come back to the patrol car?
No.
And the other thing, I mean, I guess the reasonable suspicion, what the officer articulated were his subjective belief that Mr. Shimer and his passenger were nervous his subjective belief that they were off route, and then his subjective belief that it was odd that he didn't get out of the vehicle. Is that correct?
There was a lot more than that, Judge. One was that, and I pointed this out in my brief, it wasn't that both occupants were nervous, but they were extremely nervous. And the testimony during the suppression motion was that their extreme nervousness was far beyond what Officer Blake witnesses during a regular traffic stop. And so our appellate courts have distinguished the difference between mere nervousness and extreme nervousness. The other one of the other factors was that this was an expensive one-way rental. And the officer testified that based on his training experience, one-way rentals are often used by drug traffickers. And I believe our appellate courts, both state court and the 10th Circuit, have both found that one-way rentals are commonly used by drug traffickers. Then there
Counsel,
was...
Mr. Cruz, can you refresh my recollection as to
Sure.
at what point in this stop did he learn that this was a expensive one-way rental?
When he got the rental agreement. So that it was right at the beginning of the traffic stop.
So at the time that he had received the driver's license and other documents?
Yes, sir.
Okay.
So before he got back in his car. Then we also have, so he had his driver's license. He saw the rental agreement, noticed that according to the officer, they were off route. And again, could have been completely innocent behavior. However, I believe the U.S. Supreme Court in the Arvizu case has held that basically you hold the factors not compared to the average person, but a trained officer. So you have to look at it through his eyes, not just the regular person, if you will. And then there was a couple other things. I believe that the fact that he left his blinker on, which we didn't really argue because I've left my blinker on, so the thing happens. But the officer that weighed in, and I think there was one other factor that the district court also found, which I don't recall. So there was a myriad of factors that the court found constituted reasonable suspicion. So as far as the speedy trial, that issue goes, I'd ask the court to look at that, I believe it's the February 7th or February 8th, 2018 hearing, where there was a, that the court took up the speedy trial issue and I think pointed out exactly what happened during the case. And granted, this was a very long case, that it was exacerbated by, in part, by the fact that Chief Defense Counsel for Mr. Shimer passed during the case, and he had several health issues during the case, and then it was taken over by Mr. Williams. So, but I believe I outlined in my brief that the majority of the delays, except for maybe 131 days, are attributable to the defendant.
If we were to take out those days, would this been within the speedy time, or do we have to rely upon the waiver?
No, I think that the waiver, absent the waiver, I think that the amount of time attributable to the state's 131 days total, because all the other delays were at the request of the defense or caused by the defense.
Judge Gardner?
Well, I think after the hearing you're talking about, didn't the state and the defense still charge time to each other? So how is that consistent with your argument there was a complete waiver?
What do you mean, ma'am? I'm sorry.
Well, if there was a complete waiver of speedy trial early on in the case, then you don't need to charge time to either party when you request a continuance. But it seems like the parties still did that. Is that right?
Yes, Judge. And the reason why I did it, Judge, was I've actually lost a speedy trial issue that wasn't raised at the district court level. It wasn't raised at the Court of Appeals level, that it was raised sua sponte by the Kansas Supreme Court. And just to cover myself, I wanted to make sure that at least there was that indication that the state was actually trying to make sure that we had complied with everything. So just in case anything fell through the cracks, like here, that at least we had some record that we were trying to get his case on track, and we weren't just dragging it out.
Thank you.
Sure. So I'd ask the court to deny that their request to overrule the district court and uphold his convictions.
Thank you. Any other questions from our panel? Hearing none, Mr. Kittle, rebuttal.
Thank you, Your Honor. Let me try to address some of the questions that were asked during Mr. Cruz's argument. The fact that one of the factors used to show reasonable suspicion of criminal activity here was Mr. Shimer's decision not to go back to the patrol car. I would submit that that is not suspicious. He was told by Blake that he was completely within his rights to stay in the car, and to claim that that is somehow some suspicious activity is using a defendant's exercise of his rights as a sword against him, which I think is improper.
Counsel, I think Mr. Cruz told us it was the language he used, sort of the sophisticated reference, am I being detained, that was suspicious.
To me, the language, it's a perfectly good question. There's nothing wrong with the word detained. We've used it here today. Now, we're lawyers, but I mean, why should those words be unavailable to somebody on the highway and automatically make that person a suspicious character? I think this isn't a matter of suspicion. It's a matter of frustration on the part of Blake, who, when Mr. Shimer doesn't want to go back to his car, isn't able to launch into his routine where he goes there and starts asking a bunch of questions. The standard here on detention
Mr. Kittle, before you move on from that, obviously, as you pointed out, this officer has been involved in some other cases. What I would like to know, and what I did not see in this record, is was this issue brought up before the district court to challenge the officer's credibility? And if so, I mean, it seems like the judge found the officer to be credible. And if it wasn't brought up, can you bring it up now?
Well, I think it was, at least, I think the arguments were made that, look, Your Honor, when you look at this video, this clearly is, Blake has said you have to be 3 or 4 seconds ahead of the car you're passing. If you look at the video, Mr. Shimer's vehicle doesn't appear to be 3 or 4 seconds ahead of the car that's passing. So
I understand it's this specific case. What I'm asking about his general reputation and things like that you're delving into appellate cases to glean.
I'm not trying to impugn his character. I'm just saying that if you look at the record here, when he says to Mr. Shimer, you don't have to come back to my patrol car, but then uses that as some sort of suspicious thing because whether because he refused to come back or because of the language used, I think that is a valid question as to why Blake is saying that when Mr. Shimer does what he says he can do, it's somehow suspicious. And again, the cases from the Kansas Supreme Court say measurably extended. Mr. Cruz argued that Blake was frustrated because the information wasn't immediately forthcoming from dispatch, and that's true. And I think the record does indicate that he was frustrated, but the standard is measurably extended. He didn't call dispatch right away. So even if it took 20 minutes from the time he called to get the information from dispatch, that wouldn't have been 20 minutes if he had not first called Epic. It would have been less than that, whatever the time was that it took to deal with Epic until he finally decides he's going to call dispatch. That is the period which was measurably extended beyond what was necessary to deal with license, registration, and warrants, which
so
is—
Mr. Kittle,
Yes.
It looks like in the record, the time between he called Epic and the time he called dispatch is about 2.5 minutes. So would you say that's measurably extended if that's correct?
Yes, yes, because, you know, you said it was 2.5 minutes, Your Honor. You've measured it. It's been extended. And so that's a violation of the law, according to the Supreme Court
Under that
jurisprudence.
definition, counsel, I suppose 30 seconds is measurable.
It could
and
be
extended. I
but-
mean, that the point I think Judge Gardner is trying to make is does this reach the level of our legal definition of measurably extended? And I'm not sure you answered that question about the 2.5 minutes. Could 2.5 minutes constitute being measurably extended based on our legal definition of that term?
I think it could, yes, certainly. Again, you know, if it doesn't make any difference that there was a delay with dispatch, the information from dispatch could have come in a shorter time after the stop of the car had Blake immediately called dispatch instead of going through this exercise of calling Epic and really not knowing what information he was going to get that had any that would be in any way pertinent to the purpose of the traffic stop.
You're over your 3 minutes rebuttal, but I'll let you wrap up.
I think we have multiple violations here. We have an illegal detention. We have an improper car stop. I think we have a speedy trial violation. I didn't even touch on the third issue, which deals with the sufficiency of the evidence. I want to make sure that the court considers that because I think that's a good argument. Based upon all of this, I would ask that there be a reversal of Mr. Shimer's convictions based upon the Fourth Amendment violations, reversal of his conviction for the conspiracy, and a discharge from further prosecution on that because that's a sufficiency of the evidence issue.
Okay. Any questions from the panel? If not, we thank you both. Good arguments this morning. We'll take this case under advisement and try to get